who is an attorney in Pikeville, Kentucky, with offices throughout the Commonwealth as well. I have known Mr. Jones for, I suppose, almost 20 years now. He rescued me, as he will tell it, from the other side, plaintiff side of worker compensation, and has had me do worker compensation cases for defendants who he represents. And he is going to be talking with us tonight about worker compensation. And as always, he is full of surprises, and we'll see what the surprise is tonight. So, Mr. Jones, it's a pleasure to have you here. Thank you for coming, and I'll turn it over to you.
I'm up. Well, happy, I think it's Tuesday. Happy Tuesday to everybody. These days run into me. I get to trying cases, and the weeks run in, and the days come in. And by the way, my shoes are coming off. Usually it takes about 20 minutes, but I got to get comfortable. I left Pikeville about 5:30 this morning, went to Hazard and tried a workers' comp case. Left there and went to London, tried a workers' comp case. Came up here and worked in the office. We'll do this tonight, and then I'll get back to Pikeville about 10 o'clock or 11, start all over again. So if I go like this and fall, I'm just tired. But I'll try to make it as entertaining as I can. Workers' comp is a very serious matter when people truly do get injured and do get hurt. But you've got to have a little fun in the academic world. I've been a part-time professor at UK at the law school in the past for 2 or 3 years. I gave too many A's, so they told me I didn't follow their grading curve. So I said, I'll see you, because I was teaching for free. So I went, fire me, it'd tickle me to death. Of course, they didn't, and they wanted me to come back. But I went up to Chase and taught about 6 years, Chase Law School. I taught over at Grundy the year that they had that shooting over there. I don't know if y'all remember, but a dean got shot over there. Some students got shot, and it was a very terrible thing. I was actually supposed to be teaching a class that Wednesday, but I wasn't there. And 2 of my ex-students were police officers from North Carolina, somewhere else, and they actually got the guy and corralled him down. And I said, guys, I can't believe y'all didn't have an accidental shooting. I said, because you know it's going to be insanity, and we're going to have all these problems. And he killed like 4 or 5 people, cold blood. And of course, I do believe in due process, and you ought to have it. But that was a real tough situation for that school. It was very, very hard, but they got through it, and they're accredited now. And so now in Pikeville, we now have an osteopath school, so you can become a doctor in our little town, or you can go over to Grundy and be a lawyer, which we never had when I was growing up. We always had to come here or go way out of state or to different places. So our area is growing, and hopefully our coal will continue, and hopefully things will go good for us down in eastern Kentucky. But I've got a license in Kentucky. I'm also licensed in West Virginia. I'm licensed in Tennessee. I'm licensed in Georgia, and only because I got a condo at St. Simon's Island so I can write my trips off. That's very important for me. And then I just got sworn into the Alaskan bar, and I'm probably the only Kentucky lawyer that's ever been sworn into Alaska. And everybody said, why'd you do it? And I said, because nobody else has ever done it, and I just wanted to do it. So my partner says, well, why are we paying $2,000 for you just to do something you want to do? I said, because I just want to do it. So I did. So now I'm going to practice Eskimo law, and I'm really looking forward to it. I'm looking forward to going up to Anchorage. I really want to go salmon fishing, what I really want to do. So that's what I hope my deal will be. I want to tell you all something about Dr. Crystal that you all don't know that I do. He and I have been doing this for a long time. He is an expert's expert. You don't have any clue how well he holds up in court. He is very credible. The key in workers' comp and the key in all of life is credibility. If you're credible and people believe you, then good things happen. If you just say things for the money, how many of y'all think that I can buy a doctor from an orthopedic or a pulmonary or anything to say anything I want him to in court? How many of y'all think I can? You can. I mean, I hate to say it, but it's there. And it's a real shame when lawyers play games with people's true medical condition. Whatever your condition is, that should be your condition. If you've got a herniated disc, you got a disc. If you got a sprain, you got a sprain. If you've got RSD, you got RSD. I mean, whatever your condition is, the doctor should agree on what the condition is. They might not agree on the restrictions or what you should do with your work activities, but they ought to be able to agree on at least what the major condition is. But Dr. Crystal can't be bought. He was on the other side when I first met him. He was doing depositions for Edmund Collett down in Hyden. And I came up to take his deposition years and years ago, and Edmund had not sent him all the medical reports. So by the time I was through, I gave Dr. Crystal the medical reports from the physicians that I had used, and it just changed his mind. He said, first he said this person was disabled and couldn't do anything. He said, of according to what I've just seen from Mr. Jones, this person can go back to work, and there's not really much wrong with him because it was a one-sided report because all the doctor's reports were not given. So I said, that's an honest man. I walked out there and said, that's an honest man, because I've done probably as many depositions of doctors from orthopedic, pulmonary. I do a lot of black lung work down in Eastern Kentucky, representing the coal industry. And I know who's telling the truth and who's not. After you've played this game a little bit, you know who's a straight shooter, and he's a straight shooter. And so I call him the money man. And you're going to find out why tonight. He is the money man. I only use him on very, very serious cases. If it's a sprain or a strain and people are truly not totally disabled, I don't need him because the judge will give a partial award, we pay the award, and we're done. But now when people start saying they're totally disabled and they can't do anything and can't go back to work, then I've got to use him. I got to use him to say, are there jobs that this person can either be transferred to or do in a competitive economy? And he'll tell me the truth. But I'll send him all the medical. I don't just send him a portion of it. I said, I want the truth. Just tell me the truth. Then I can deal with my case I have to deal with. But he is respected as probably, what happened? He is respected probably as the top vocational expert in Kentucky. I don't have any doubt in my mind. And I'd say nationwide he is very well thought of. You on any type of committees or anything? No? You don't write any articles or do anything? Maybe I better rethink this. But anyway, you all don't really know how fortunate that you are here at UK to have this gentleman, because he is very well thought of and he holds himself up well in court. The judges believe him, and when he says something, they believe him. So I kind of know when I go in to my case what's going to happen if I've used him, because that's the truth. So he really, sometimes he thinks he's smarter than the lawyers. A lot of times I'll say, Dr. Crystal, just say yes or no. Be quiet. Don't start talking all this other stuff. Just give me a yes or no. But he wants to explain it, and that's okay. And tonight, after I finish with the workers' comp, we're going to do a real quick summary of workers' comp from start to finish. We'll do Kentucky workers' comp. And then I've got a deposition in the back of your all's handout. What I've gotten is I've given you a medical report on a case that I'm actively trying down in Eastern Kentucky right now on a gentleman who's going for total disability. And I'll go over the fact situation with you. Then we're going to pretend like we swear him in. And then we're going to do a direct and a cross-examination, just like we do in court, of him. And first I'll be really nice to him because he'll be my witness, but then I'll get on the other side and try to tear him apart, because then I'll be representing the injured worker instead of myself. But I won't do that to you. You're just too sweet a guy. Look at that face. How could you tear into that? So anyway, that's what we're going to do, and that's how we're going to do it. The first thing y'all need to know in workers' comp is workers' comp goes back to the 1910s and the 1920s. What happened was, before we had a workers' comp system, we had court cases, just like we do with automobile accidents, wrecks, and all that kind of stuff. So the cases would go to circuit court. They would not go to a comp system. They would actually go to the courthouse, like that down here at Fayette Circuit Court. Nobody really liked that, because those cases took a long time to try. Whether you all know it, the law is a slow-moving creature. When you get involved in the court system, sometimes it just drags and drags and drags. And lawyers like to kind of make it drag and drag, because at $150, $200 an hour, they're wanting a little dragging going on. And so those kind of things happen. And so what happened was, in the 1920s, when the Industrial Revolution came, we started getting more and more injuries. You know, before we were a farm economy, and we didn't have a whole lot of injuries. People weren't losing their arms and their legs and all that kind of stuff in workers' comp accidents. But after that started coming about, more and more people got injured, and they got disillusioned with the court system from both sides. The injured worker didn't like it because the employer could drag out the case forever and ever. They couldn't get their medical bills paid. But once they did get an award, they got big awards. Once they got to juries, juries tend to give big awards, okay? The employers didn't like the big awards. And the employers said, we've got to have a system in the employees that is very quick, very speedy, that gets injured people their money, gets them back to work if they can. If they can't, get them on the wage replacement theory, and let's move on with life and get their medical bills paid. Before the comp system came about, the employer could use contributory negligence as a defense. So let's say somebody went out and got hurt and they contributed to the accident. The employer could just show that the employee contributed that much to the accident, even though it was primarily the employer, and the employee got nothing. So contributory negligence knocked out a lot of claims. So workers' comp became a no-fault system. It doesn't matter if you stick your hand in a fan. You're going to get compensated. It's no fault. I mean, it's no fault. And so we don't fight over the fault of it. The only time fault comes into play is if you try to decrease an award because of somebody's fault. But as far as actual payment, fault is irrelevant. So you can see that speeds up the process tremendously. Plus your medical bills are paid immediately. Within 7 to 12 days, the minute you're done, you'll start getting a check, your medical bills are paid and you're ready to go, so long as you're not fighting the compensability of an issue. So it's a very quick system. The employer's got exclusive remedy. That means that the employee cannot sue in tort. They can only go in workers' comp unless they elect out of workers' comp. So the employer got capped liability. In workers' comp, I don't know if they've already told you, they can get like 66 2/3% of their average weekly wage. It's a wage replacement. If you're totally disabled, you're going to get, from a workers' comp injury, you're going to get 66 2/3% of your average weekly wage. And then by that time, if you are totally disabled, you're going to get your Social Security, you're going to get your Medicare, Medicaid, and other different things. So you should be pretty well up to where you were post-injury, okay, or pre-injury. So that's a good thing. If you can get it quickly and to the people that deserve it, that's what you ought to do. That's what comp is about. Comp is either done through insurance, and I represent insurance companies, or it's done through self-insured. A lot of people are really big. A lot of our co-companies just insure their own risk. They don't buy insurance. They just pay it directly as they go. Now, whether they're going to be able to continue to do that, we'll see. But that's where we are now for that. So that's how this system came about back in the early days, and it's been around ever since. And it's a very, very good system when it works properly. And about 90% of our cases, gang, I settle. I mean, we very rarely have hearings. Today I had a few, but we settle about 90% of the cases. Two good lawyers that have practiced workers' comp can take any case, get the impairment ratings, figure out what that case is worth within $10,000 of each other, settle that case and move on. And if you don't, there's something wrong with you. You need to get cases settled. I'm serious. You need to get cases settled, and you need to get the system working properly, and you need to move on. But now, every now and then, we just have some major problems that we can't resolve. But most of the time, 90% of the cases are settled. Now, what about Kentucky? Kentucky, you got to remember 3 different time periods, and I think it's in your outline there. 1972 to 1996. I hate to tell you how old I am, but I was practicing during most of those years. I think I started in 79, and I've been practicing for 32 years, and it has really been a blast. But most of my time was spent during these early years of practicing what's called occupational disability. The workers' comp system used to be based on an occupational disability standards, which means a judge will look at what the doctors say, Dr. X, Dr. Y, and that judge will say, based upon that person's age, their education, their work experience, and the area in which they live. The area in which they live, I find that this worker has 5%, 10%, 20% total disability. The judges had complete discretion, complete discretion. So you can imagine if judges have complete discretion, sometimes you're going to get some pretty whacked out decisions because a lot of judges are liberal and a lot of judges are conservative. And that's just their bent. That's their nature. They come into the job that way. And we hope that everybody's the same and fair, but it doesn't happen that way in this world. So we had a lot of judges that were given some really far out awards. What we had was, remember the area in which you live, that's the key. We had people in eastern Kentucky where I live who were coal miners. And that's what they did for a living, okay? So they're doing heavy manual labor most of the time. They'd have a sprain or a strain. They would have 5% impairment. The person up in Lexington would have a strain or a sprain, but they're working in some job in Kroger's or somewhere or doing whatever they're doing. Well, that person in eastern Kentucky has the same medical condition as that person up in Lexington. But who do you think is going to get a total disability and who's going to get a 5%? The coal miner down in eastern Kentucky would get a total, even though it's the same medical condition, because in the area in which he lives, they wouldn't make you move. In the area in which he lives, what's he going to do if he can't do coal mining? And how's he going to make that money? How's he going to make $70,000 a year? He's not going to do it, okay? So we had a system where one person would be the same as another person in Lexington because there's 10 times more industry, and in Louisville, that person doesn't get a total disability. They're expected to go to work somewhere else, okay? But in eastern Kentucky, they weren't. And what we had in our system at that time, we about went broke up until 96 when I'll tell you about the reforms. But what we had was we had a system that was just runaway. When everybody would file their claims, they would come out and they would work every day until they were laid off, okay? They'd get laid off in the mines. Then all of a sudden they had a black lung claim. Then they had a wear and tear claim on their back. Then they had a psychological claim. Then they had a hearing loss claim. They had 5 claims. And I'd say, now Fred, I said, were you working every day till you were laid off? Yes, sir, Mr. Jones, I was. And then the next day you had 5 medical conditions that rendered you totally disabled? Yes, sir. That's what my lawyer said. I was like, okay. And that's what we went through. And the black lung really got out of hand. They were giving everybody with stage 1 total disability, which we later corrected. And so the special fund, we used to have a fund that paid 3/4 of those awards, so the entire state of Kentucky was paying for it, all of industry. We were like billions of dollars, whatever we were, in debt, so they just had to do away with it. I mean, the system was about to collapse in 1996 when Governor Patton came in and did the reforms. Did he go a little too far? We'll talk about it in a minute. Maybe, maybe not. But he had to do something because our state was going bust. And we were at a terrible economic disadvantage with other states who weren't paying these exorbitant workers' comp fees and weren't paying all this stuff that they shouldn't have been doing. So the occupational disability is what I practiced under for years and years. And the way that it worked on a black lung case is Kelsey Friend used to make a fortune on this. We had Kelsey Friend, a lot of my lawyer buddies, he's dead now, but Kelsey was in the legislature and he wrote the law and then he practiced under it, okay? And he made a fortune off that thing. And Greg Stumbo, a good friend of mine who's the speaker, he used to do a lot of black lung. We had a lot of lawyers down there, Herbie Deskins, a lot of folks doing a lot of black lung down there and making a lot of money. And the occupational disability standard was perfect for them because they would send them to a doctor. That doctor would say, yeah, they have black lung, but they don't have any breathing impairment. They're not disabled, but they have a spot on their lungs, okay? And then they'd say, well, doctor, should that person be to work, go back to work in the mines? No, not if he's got black lung, regardless of whether he's got any disability or any impairment. It doesn't matter because it may progress to a higher stage. So if they went to a doctor who told them that, whether he really had it or not, he was occupationally 100% disabled because what coal company is going to hire somebody that a doctor's told them they have black lung because you work 1 day for that company and that company gets the bill. 1 day, even though he had it before he went to work there on black lung cases. So my dad did pre-employment exams for most all the companies in eastern Kentucky when I was growing up. Dad had a case. They sent him to Dad for a pre-employment exam. Dad did it. The guy went back on in, went to work, and Dad said, don't go into work until I get the results from these x-rays and stuff. Well, the company put him underground anyway. Dad found it and said, well, you got some black lung. He called over to the mine. They took him out of the mine. He worked 4 hours, and it cost him $200,000 or $300,000. I mean, that's a lot of money for 2 or 3 hours work. So, you know, you got to kind of watch out what you're doing. So that's what happened on the black lung portion. It really just got out of hand, and we just had, you know, I lost cases that I couldn't believe I lost. I mean, I'd lose to 32-year-olds. I'm going, I must be a terrible lawyer. I mean, this is terrible. But they would come in one case, Chad Perry, he's dead. Chad Perry came in, and this guy was like 28 years old. He'd worked 10 years in the mines. And he came in, and he had 32 x-ray reports of doctors. I didn't even know there were 32 doctors that read black lung x-rays. They were from everywhere. So I called the company. I said, well, this is a real expensive case if we lose it. I said, probably nothing wrong with the guy. I said, what do you want me to do? They said, well, what can you do? I said, well, I can either get 32 too if I can find them, or, you know, we can just pay the case. They said, get 32. So off I went. And I was getting people from Johns Hopkins and Harvard and people I'd never even heard of. And that showed how ridiculous the system was. I used that in the legislature when we got the reforms passed. I brought all those reports in there, and everybody in a Labor and Industry Committee went, holy smoke, this is terrible. I said, yeah, no kidding. So all that stuff, the abuses that happened in the past, all that led up to what had to be some reform in workers' comp and to get rid of this occupational disability standard. And what the legislature wanted to do, they wanted to make it objective. They wanted to tie it into medical findings. If you've got a condition, the doctor should be able to tell you, yeah, you got a problem, yeah, you're disabled or not, yeah, these are your work restrictions, and yeah, go back to work or be retrained for something else. I mean, this is not rocket science. This is really pretty easy to me. So that's where we ended up, and that's where we were with the occupational disability standard. After that, now functional disability is completely different. Functional disability is, let's say that I lost my arm. If I lost my arm, every doctor will say my impairment is 5%, 10%. They use the AMA guidelines. Have you all studied the AMA guidelines? That's the American Medical Association guidelines. There's a book that rates everything. If you've got a back strain, it tells you how much your disability is. If you've got a psychological issue, it tells you what your disability is. No matter what your medical condition is, you're rateable. So if you lose an arm, that's your functional disability, okay? Let's say that my arm is gone. And let's say a coal miner's arm is gone. Now that coal miner is a roof bolter, okay? He's got to have both his arms to do what he's supposed to do. So even though we're both going to have a 5 to 10%, whatever it is for the loss of our arm, his occupational disability is 100%. Mine is 0, because as long as I've got this big fat mouth, I can stand up in front of juries and argue all day long. It doesn't affect my occupation whatsoever, okay? So my occupational disability is 0, but his occupational disability is 100%. That's the difference between functional and occupational disability. Any questions on that? This is free legal stuff. Surely you all have had a workers' comp case or something in the past. But now, this is free lawyer stuff, so you know this is usually about $125 an hour, so that's a pretty good deal for you all. So that's the difference between the two. They wanted to get back to a functional type of disability standard rather than occupational because the judges were going a little too far this way, so they wanted all the judges to try to have consistency. They were just trying to find consistency in the framework of workers' comp, which is a good thing. If you can get it, you know, it's a good thing if you can get there. But every time the legislature meets and changes the rules, the things change. Because if it's a very hard rule and very hard and fast, not many people get what they're supposed to. If it's very loose, everybody gets everything. So where do you come, how do you find that medium ground to do the right thing for people that are truly injured? And that's what everybody should be looking for. That's what the whole system's about. So in '96, after the state was about broke, they even commissioned a study up here at UK. We actually hired from the Coal Association, the University of Kentucky. I can't remember the guy's name. You remember his name? Baldwin or somebody? He was a really good economics professor up here. But he studied
Baldwin at Transy.
Maybe it's him. Maybe it's not, I don't know. But anyway, we hired somebody, and he put together a great report for the legislature to show what was going on with all the games and the stuff. And if you ever really want to look at workers' comp from a historical perspective, find whoever that was or call my secretary or call me. I think my number's on there. And I'll be glad to find it for you because it really is very interesting. So in '96, Governor Patton came in, and Governor Patton said, we're going to change this. Now, Governor Patton is my next-door neighbor. He's been a friend for years, and he was an ex-coal operator. I don't know if you all know that, but he was an ex-coal operator, so he understood some of the abuses that had happened in the workers' comp system, and he understood the lawyers because we used to have a lot of fun times, all of us lawyers at one time, back before we all got old. But Governor Patton said, I'm changing this. This is not right. I'm going to get with the legislature. I'm going to have task force and studies and studies and studies, and he studied me to death. I felt like I was a rat in a maze. What's about this workers' comp? What about this hearing loss? What about? I said, Jesus, chill, Governor Patton. He called me on my birthday. I was up here at the Hyatt Regency with my wife. It was about 1 o'clock in the morning, and I was sitting in there in a motel room, and they said the governor called. The governor's on the phone. I said, well, tell him it's 1 o'clock in the morning, and I'm going to bed. And they said, no, you need to take the call. I said, all right. So he said, would you like to come down here and testify in about 4 hours in front of labor and industry? I just went, click. No, I really don't want to, because I'd already done all I could do with him. But that is a true story. But he's a good guy. He tried to do the right thing. He called in all the various players, and he said, let's compromise this thing. Let's look at the hearing loss cases, the black lung cases, the injury cases, and let's come up with a compromise of where we can be and get everything done. Well, the plaintiffs' bar on the other side, and as you all know, there's plaintiffs and there's defendants. I'm a defendant. The plaintiffs are the ones that sue, and the plaintiffs' bar is a lot more popular than the defense bar because they represent the people, and that's why plaintiffs' attorneys get elected to the legislature, and that's why they get elected to our Supreme Court, because all the people know them, and the people like them, and they represent them, and they get them money. Well, I'm holding back on their money. But really, I want to give people their money as soon as I can, but I can't get elected dog catcher. And I tried to do the right thing and be very nice about it, but the plaintiffs' bar are the people that are out front, and that's what they do, and they get elected. So, and I always tell people, how important do you think the law is? When you go to court, you got a lawyer on this side, and you got a lawyer on this side. When you go to court, you got a lawyer sitting up in front of you who's the judge. After that case is over with, you go to the Court of Appeals. You got a bunch of lawyers up there that are all on the Court of Appeals. If you go to the Supreme Court, it's all lawyers up there. So we're it. I mean, we get to do it all. I said, what a great way to make a living. I said, I can challenge any law I want to say it's unconstitutional, take it to the Supreme Court, and I may win. I just may win. And to me, it's just a privilege and an honor. I mean, I can't believe they still let me practice. But they do, and I really enjoy it. So anyway, what they did, what you got to keep in mind, there's two things when you're talking about workers' comp. There's only two things. There's the definition of injury. What's an injury? And then there's the definition of disability. What's disability? The definition of injury is like an hourglass. Look up at the very top. If you fall within the definition of injury, you come down in that hourglass. If you fall outside of the definition of injury, you don't have a workers' comp case. But if you fall in that definition, you got an injury. Then once you get in that little rattle hole, then you go down to disability. And the question is, how much money are you going to get? Okay? So those are the two things. So if they tighten up the definition of injury, you think there's more claims or less? Less. Less. If they tighten up the definition of total disability, is there more money or less money? Less. If they open it up, there's more on either side. Okay? So what they did was, the definition of injury before 96 was any harmful change to the human organism. Now think about that. What does that mean? Any harmful change to the human organism. That's the most liberal definition that there was in the country. If I pick my nose and scratch it and bleed, that's a harmful change to a human organism. I mean, I'm dead serious. It was so liberal, it was ridiculous. Okay? Everything was a work-related injury. It didn't matter what it was. And I'll talk about it in a minute, the mental claims. That'll really get you going. But the definition of injury was any harmful change to the human organism. So what did we do? We tightened up the definition of injury. Now, the definition of injury is set forth for you right in here. Injury means any work-related traumatic event, and it goes on, measured by objective medical findings. Before, we never had to have objective medical findings. Now we're going to put the doctors to the test. You're going to have to tell us objectively, is there something wrong with this person? Not just, oh, I like old Joe Blow. He's been my patient for 30 years, and he's disabled. He can't do anything. That's the way the reports used to be written. Well, that doesn't tell me what the CT scan shows or what the range of motion study shows, or objectively, is there anything wrong with this person? So we tied in objective medical findings. Injury does not include the effects of the natural aging process. Before, every one of us in this room have degenerative disc disease. Since the day we're born, our discs start degenerating. Okay? Now, some go faster than others. But a lot of it's natural aging process. It has nothing to do with a work-related injury. It has nothing to do with your job. You're just getting older. Okay? Period. So, but in the past, if you had degenerative disc disease and you bent over to do something or pick something up, and all of a sudden you had a problem, even though it was due to the natural aging process, that was an injury. Well, do you think everybody didn't have that? I mean, anybody can have that. I can just walk into my office, pick up a file, and my back starts hurting because I've got degenerative disc in my back. Has nothing to do with me picking up that file. So, you know, it was just a snowball effect. It was so liberal for the natural aging process, they said, we're going to write out the natural aging process. An employer should not have to pay for somebody's natural aging process. They're just getting older. So it says, does not include any communicable disease unless the risk of contracting it was increased by the nature of employment. That's the AIDS stick. Most communicable diseases will not be deemed to be an injury under comp, but like a nurse with a stick, with some AIDS or something like that, that's going to be compensable, and it should be compensable. Injury, when used generally, unless the context otherwise, shall include an occupational disease. That's the black lung cases that we've talked about. But shall not include, and this was the key because we were having so many psychological claims. Everybody from Eastern Kentucky, when they filed a back injury claim, had a psychological claim. Everybody up in Lexington, Louisville didn't have those psychological claims. And I thought, Lord have mercy, if there's that many people in Eastern Kentucky with psychological problems, I'm getting out of here because I don't know, they're all going to get on dope and all kinds. You know, we got an epidemic with drugs, as you all know. And but anyway, the psychological cases we had to tie them into a direct injury. You can't just say, well, I don't feel good, my head hurts, and I'm nervous. Well, you know, I'm nervous too, but, you know, that's the way it is. Is it due to that work-related injury? So the first case that we had, it was a doozy. We were having cases that I call mental cases. I had a case where a lady was working for Super America in Martin County. We caught her stealing. She was taking cigarette coupons, and she was putting them in the drawer like she'd sold them, taking the money for the coupons, and we caught her stealing money, okay? So Super America calls me and said, what should we do? I said, what do you mean, what should you do? Fire her. Well, she'll sue. I said, let her sue. I said, let her sue. So she files a psychological claim that we fired her for stealing and thought that should be compensable. I had to take that all the way to the Kentucky Supreme Court. It cost Super America $10,000 to pay me to win that case. I thought, this is ridiculous. And that's when we went in after this kind of stuff. These are the kind of stories that got to the legislature so they could make the changes. They didn't know, so they could make the changes that were what's going on. The next case was, and it was very interesting, and the question is it a direct result of physical injury? It was another Super America case. And on that Super America case, it was in Pikeville. And what happened on that Super America case, a guy was robbing the Super America. So the guy was robbing, the lady was actually in her car. She was going to make a deposit. He came over and busted the windshield out and grabbed the money bag and left. Okay? She files a workers' comp claim. Well, they called me and said, what should we do? I said, well, it's not the direct result of a physical injury. I said, she didn't have a physical injury. I said, so if you want to deny that case, you're probably within your right to do it, and we'll have to litigate it. And I said, but the problem is, I said, if this is not covered by workers' comp, are we going to be in circuit court because we're going to lose our exclusive remedy protection, and you don't want some lady that's been, robbed at 1 o'clock in the morning going to circuit court on us. If we didn't give safety precautions or you didn't do what you're supposed to do, you need to really think about this. So I called her lawyer. I said, I don't know if this is a workers' comp claim or not. I said, have you read all the medical reports? Because I already knew what the medical report said. He said, well, yeah. I said, well, kind of look at the one where there's a little scratch. And when the glass came in, one of the medical reports from the hospital said there was a little scratch with a little bleeding on the lady's neck. That's a physical injury, okay? That made it a workers' comp case. They got to get in the workers' comp. We got to forget about all the other stuff, stay exclusive remedy. We settled the case, and we were done with it. But I think, under what we were saying, if there wouldn't have been that scratch, I don't think that would have been a workers' comp case if the employer just didn't want to pick it up. A lot of times they'll just pick it up anyway and just go with it because, they want to take care of their people. I've never, in all the years that I've practiced, I've never had one insurance company or one co-company tell me, don't pay those people because I don't like them. Don't do it. Because I always tell them, if you tell me that, you can come get your file and you can take it to some other lawyer because I'm not handling your case. And they know that's the way that I feel. And when I call them and I tell them something's legit, they usually say, no problem, let's go with it. I usually don't even have to document my file, which is kind of nice. A lot of lawyers try to cover themselves and write so much paper. I don't like to write a lot of paper. I like to make some phone calls and just say I'm done. So that's the way that came in. So you can see the definition of injury went from any harmful change to the human organism to all this stuff added in. That's a big change. That's a big change. So the volume of claims, we were having I forget the number, maybe 5,000 and 6,000 claims a year, went from 5,000 and 6,000 to 1,200 because, those claims just weren't there anymore because all those that were halfway manufactured were gone. So then the question is, what happened to the definition of disability? Remember, disability was occupational disability, all right? Now, look at the new definition of disability. Permanent total disability means the condition of an employee who, due to the injury, has a permanent disability rating, and this is key, and has a complete and permanent inability to perform any type of work as a result of an injury. That's a pretty strict standard. Any type of work. Everybody said, well, Paul's going to argue that they can, go over here and sell pencils or do something. I said, no, I'm not. That's ridiculous. But that definition is almost like a Social Security definition, and it's the strongest one we've ever had for total disability in Kentucky. Now, just start thinking about why Dr. Crystal is important. Dr. Crystal is important because he's the one that's going to say, does this person have a complete and permanent inability to perform any type of work as a result of the injury? He's going to get all the medical reports. He's going to do his vocational testing. He's going to come up with a conclusion that there are or are not jobs in a competitive economy that person can do. He's the money man. He's the money man. And he's the money man in circuit court cases. If you get injured in a car wreck and you have lost your ability to earn wages, somebody's got to figure out economically how much is that worth and put a number on it for the jury. Who do you think does that? Him. Okay? So he's the guy that does it. And where people trust him, it's awful nice because we can just hire one expert and say, whatever he says, that's what we're going to do. So we kind of mediate through Dr. Crystal. So that's what the definition of disability is. So you can see we've changed the definition of injury. We've changed the definition of disability. Things got tightened up. And our workers' comp environment improved because people started coming back, industry started coming back. We actually had people leaving the state of Kentucky because of workers' comp. And that was really sad. That's sad. It shouldn't be that way. So then what happened? Well, we went along for about 4 years. From 96 to 2000, things were kind of hunky-dory. The plaintiffs were really griping. They said, no, their people aren't getting enough money and it's all this. And some of that is a little true because it got pretty tight. It got pretty tight. And so what happened is, as usual, the judiciary will right any wrong, okay? So in 2000, we had our first case to come out and tell us how all this definitions and what all this means. It took 4 years to get a case up there to tell us what's going on. And, of course, it's a Pikeville case. Pikeville is the suingest place in the world. If you're going to be a lawyer, you want to go to Pikeville. There's plenty of work. They like to sue down there. And, it really is something else. So we had a Watson's Department Store versus Hamilton. I think that's on page 2 of your outline. And that case was very interesting. This guy was 42 years old. And if any of you all know anything about Watson's Department Store, it's like a People's or a Pebbles or whatever you call it, or a Target. It's just a department store, okay? It was a tiny store down in the plaza in eastern Kentucky. By the way, this guy's lawyer was Eric Kahn. I don't know if any of you all have heard of or know who Eric Kahn is. But Eric, first time I met him, I went to his office, and he's down in Stanville, and he had a little trailer or 2 little trailers, and he called it his complex. Law complex. And I said, law complex? He said, yeah, law complex. I said, okay. So I walked into his little trailer, and I was getting ready for a deposition, and there were like 5 or 10 people in there, and they all had their children in there, and he had a little merry-go-round in there, like you have at Walmart or something where you put a penny in and it goes around, and all the kids were just sitting there going around having a big time. I said, I'm not at a law office, I'm at Disney World. I said, Eric, what are you doing? But that was his little gimmick, he had the kids entertained. I thought, Lord have mercy. But anyway, Eric was doing this, and he ended up winning this case. So I was kind of surprised, but he did a pretty good job on it. But this guy was 42 years old with a 12th grade education, okay? So he's educated. It's not like he's got a 3rd grade, a 4th grade. He knows how to read and write. He knows what to do. He can transfer to stuff. His work history included a firefighter, utility person, shoe manufacturer, and billboard installer. So he'd done other things other than just working the coal mines all his life. He had transferable skills, no question. He worked for Watson's for 17 years, and he last worked as an assistant manager doing clerical and administrative duties. That's not hard work, gang. That's just, using your brain a little bit and monitoring the people that are working under you. Every now and then he'd have to unload trucks, but of course he didn't. He'd get other people to do it. He injured his low back in 1997 while moving fixtures, and he didn't see a doctor for 2 days. He didn't call an ambulance. He didn't say, oh, I got to go see my doctor. He kept on working and worked for 2 more days. And then, of course, he probably saw a lawyer, and the lawyer said, yeah, you're hurt probably. I don't know that to be true, but that has happened. Then he went back and tried to continue. He quit 3 days later. He was treated by Dr. Nichols, referred to Dr. Stevens, who's a very good doctor up here in Lexington. Surgery was suggested, but they didn't really know if they should. He didn't want to do it. Now he says he can't work anymore. Okay, so we got a guy that's 42 years old. He's young. He's got transferable skills. He's got a back strain. He's got a back strain or a sprain. That's what he's got. So here's the doctors, the medical evidence. Dr. Snyder, who's a very reputable guy up here in Lexington, found 5%, no disc herniation, needed no further treatment. He just had 5%. Dr. Stevens, the same one who was the person that they was treating, said 5%, can lift up to 40 pounds. Well, if he can lift up to 40 pounds, he can work at Watson's Department Store, okay? Dr. Muckenhausen, I call her Dr. Muck, she found 27%, and that's the other side. Now, how do you go from 5% to a 27%? That's a whole lot of difference. You got to have a whole lot of disability to have 27% under the AMA guidelines. And so that's what the medical was. At that time, we had an arbitration system before we got to the judge. The arbitrator gave 5%, which is exactly what that case is, and gave a multiplier factor, which we'll talk about in a minute. That's what should have been the end of the case. They appealed it on up to the Workers' Comp Board, and they reversed. And remember the old Osborne v. Johnson I told you about occupational disability? We thought that was completely written out of the law. Well, the courts brought it back into the law. The court said, oh, no. Osborne v. Johnson's not dead. I went, what? That was the whole purpose of the 96 reforms. No, that's not fair. That we need to get Osborne v. Johnson back in there. So the Supreme Court, you can read about it all over there, but go over to the next page before you get to factors to consider. Here's what the Supreme Court said. And now this one really got to me. It is among the functions of the ALJ, that's the administrative law judge, like when you all had some judges in here, the ALJ, to translate the lay and medical evidence into a finding of occupational disability. Now we're back in, we thought it was gone, that it was dead and buried. Although the ALJ must necessarily consider the worker's medical condition, well, yeah, you ought to consider the medical condition. When determining the extent of his occupational disability at any particular time, the ALJ is not required to rely upon the vocational opinions of either the medical experts or the vocational experts. Well, if you don't have to rely upon the vocational people or the medical people, who do you rely on? Who do you rely on? And well, they're going to tell you. A worker's testimony is competent evidence of his physical condition and of his ability to perform various activities both before and after being injured. That means I just say, I'm hurt and I can't work. And if somebody believes me, I get total disability, regardless of the objective evidence. Now when I read that, it fell out of my hand. I said, uh-oh, we're in for some trouble here. And we did get into some trouble here. Like I told you, from 96 to 2000, things are floating along. After this came out, what do you think happened to the volume of claims and the amount of awards? Straight back up, okay? Straight back up. And we had what was called low-end totals. And a low-end total means that we've got an administrative law judge sitting down in Pike County looking at somebody who's got a 5% disability who says they can't work even though it's clear they probably can. And he can either give them 5% and give them $10,000, or he can give them a total and give them $500,000. Where do you think those judges, when they're sitting there looking at that person who says they're hurting really bad and they've got their lawyers doing their stuff, what do you think they're going to do on most cases? You think they're going to go with the 5? You think they're going to jack it up? They'll jack it up. So it's called low-end totals. We had a major problem. We had a lot of cases that would never been totals before, all of a sudden becoming totals, okay? So industry got together. I called down Frank and said, we got a little problem down here. I said, it's called the Watson case. Well, what's that mean? So I explained it to him, and he said, uh-oh. I said, yep, uh-oh. So when you bring in the age and education and all that stuff back in, occupational, then you have a problem, okay, as far as legitimacy of what I call the workers' comp system. So what they did was, as soon as that case came out, as soon as after we had a bunch of low-end totals, we got together with everybody and we said, how can we stop this and how can we make it to be the right thing for people and everybody else in the system? So I said, if you're going to do it, you're going to have to pay some money for age, you're going to have to pay some money for education, and you're going to have to put a dollar figure on it. You're going to have to put more money into the system because the judges feel that the injured people aren't getting enough, so they're giving them too much. So let's make it more lucrative. You're just going to have to add some factors in there and give them a little more money. And then everybody will be happy. The judge won't feel bad, the plaintiff won't feel bad, employer won't feel bad, and everybody will be kissy, hunky-dory, and we'll go on about what we're doing. So that's what we did. I didn't do it, but they got together and they said, we're going to give some money for age and education, and so that takes away Osborne v. Johnson. Remember, it's based on age, education, where you live. If you pay somebody and put a monetary figure on age and on education, mix it into the factor of what you get, then that's done away with. So it shouldn't even be involved in the game anymore. So that's what they did, and it amazes me. The factors are over on the next page, but basically what we said and what they said was if you have an injury and it's clear you can't go back to work, but you can probably do other things, we're going to take your award and multiply it by 3. We're going to give you 3 times what the award would have been, okay? And you can see I've got a couple of pages over. You don't have to look at it right now, but a couple of pages over, I've given you something, 96 law, 2000 law, same type of injury. What does that mean? Well, under the 96 law, it was worth $66,000. Under the 2000 law, it's worth $110,000. So that's a lot more money, okay? That's more palatable for the judges, more palatable for injured people, and more palatable for the employer instead of getting low-end totals. So you add, if you can't go back and do the normal job that you do, you get a 3 factor. If you go back to work doing that normal job, they cut it down to 2, okay? So it's just all these little factors that were added in, and that you've been given the reason why they were. But look at this one. If at the time of the injury the employee has less than 8 years of formal education, the multiplier will be increased by 0.04. If you have 12 years, it's 0.02. So the more educated you are, the less amount of money you get. I thought Kentucky's motto was education pays, motto. Education doesn't pay in workers' comp. If you don't have the education, you get more money. And now whether that's right or not, I don't know. But it may be because, if you're not educated, it's very hard for you to have transferable skills unless you can get a GED or do what you need to do. But, I mean, when I thought that, I said, education pays. Well, oh, boy. But anyway, so that's what was done, And that's the system that we have right now. Did they tell you when they were here how the system works, about when a case is filed, what happens to it? Have you all had that?
No, go ahead and tell us.
Okay. What happens was, let's say that, what's your name, ma'am? Krista? Let's say Krista's working in my law office, and let's say she gets hurt. Let's say I have her go picking up 30-pound files, bang, her back goes out on her, okay? As soon as she's hurt, a first report of injury has to be filled out. I, as an employer, have to fill out a first report of injury. She's got to notify me. And by the way, if any of you all ever get hurt at work, there's a notice requirement. If you don't notify your employer almost immediately or very soon thereafter, it's going to get denied. You have a requirement to notify your employer if you're hurt. Now, a lot of times we'd have people say, "Oh, I didn't think I was hurt." I said, "Well, after about a month, don't you think you'd know whether you were hurt or not?" "No, I just didn't know." I said, "Oh, okay." But if you ever, when you get out in the workforce, if you get a work-related injury, notify your employer. The employer, I would have to fill out a first report of injury saying, "You told me you hurt your back on this date. Here's what we did. We either referred you to a doctor or we didn't send you to a doctor," and that goes to Frankfurt on file. That's for your protection and my protection, for both of us. So once that first report of injury is, she either continues to work and draws her salary, or if she can't work, she'll get a hold of my insurance company and say, "I want to file for temporary total disability," which means 66 2/3% of your wages. And after so many days, they'll start sending her a check. They'll send her to doctors to see, can she work yet? If not, they'll keep paying. Sometimes it goes up to 6 months to a year that insurance companies pay, depending on how quick you recover. And I always tell my insurance company, get them to good, reputable doctors quickly. So let's be positive about this. Let's let the employee have a positive attitude. Let them know we're in their corner. Let them know we want them back to work, because we do. And let's get this thing over with. I keep people away from lawyers. I said, keep them away from lawyers. My daddy was a doctor. And I always said, stay away from doctors and lawyers. The doctors will run enough tests on you and just keep you going that eventually you're going to think you're sick whether you are or not. The lawyers are going to take all your money. So you're going to want to lose your health or your money, but you're going to get one of them if you go see one of them. So be careful about going to lawyers and doctors. And my dad always said, "Pa, that's terrible." I said, "Well, it's true." I said, "I've seen it way too many times." But anyway, so then let's say that she doesn't get better, and the doctors say she just can't go back to work for Paul Jones, and gives you a 5 or 10% rating. Then the question is, you'll go get you a lawyer, and that lawyer will review your papers and say, "Yeah, we're going to take this settlement that the insurance company did," or "No, we're not. We're going to get you more money. We think we can get you the gold mine." And then you just make your decision whether you're going to go on and litigate or whether you take whatever the insurance company generally offers you, which is usually what the percentage is that the doctors say. So, like I said, once we get in, even when we get into litigation, the majority of our cases are settled, and so it's not near as adversarial as what you all would think. And most of the people that do workers' comp have been doing it a long time. They're very good, reputable people. They really try to do the right thing. They make a good living at it. But cases have to be moved. We have to move cases through the system. It's good for everybody, and particularly the injured worker. When you're sitting there and you're getting these bills that you got to pay, and you don't have any way to pay it, you got a problem. I mean, you got a problem. You got to figure out something, and that's a tough way to go. So anyway, that's the way that works. And then after, if you don't settle with the company, your lawyer will send you to doctors. I'll send you to doctors. Then we'll go in front of a judge, and then the judge will make a decision. If we don't like what the judge did, then we can appeal to the Workers' Comp Board. Do you have anybody from the board down here?
No.
You don't think they're very important, do you?
I don't know anybody.
I'll introduce you. And then, if we don't like what the Workers' Comp Board did, we can go to the Court of Appeals. If we don't like what the Court of Appeals said, we can go to the Supreme Court of Kentucky. Only in death and murder cases do you have an absolute right to go to the Supreme Court of Kentucky for an issue. Everybody else has to apply, and they say, "Yeah, we're going to let you in," or "No, we're not." Workers' Comp is in what I can take any 5% case, and I have an absolute right to go to the Supreme Court of Kentucky. And Dan Jack Combs did that years ago. He used to do plaintiff's law. He said, when I get up on that Supreme Court, he was from Pikeville too. We got a lot of Pikeville history in workers' comp. He said, when I get up on that Supreme Court, everybody's going to have a right in workers' comp to go to the Supreme Court. And he did it. He got 4 other justices, 3 to go with him in a 4-3 opinion. He got them to change all the rules that have ever been before, and all of a sudden every workers' comp case was in the Supreme Court. I thought, man, that's wild. I mean, you know, people on death row sometimes have a hard time getting in there, and we got a guy with a back straight, and he's going into the Supreme Court. I said, Lord have mercy. So that's where we are in the workers' comp. That's how the system works. Any questions about the system and how it works?
How long do those stay on file in Frankfurt, the initial claims that go into the...
They'll stay in file forever. They're on a database.
Okay.
And they may purge them after a while, but if they do, I don't know. But because it's very important, because if I fill out that first report of injury, and let's say you don't do anything, there's a notice letter that's triggered within 2 years, because there's a statute of limitations. You got to file your claim within a certain period of time. It's like a couple of years, okay? That Frankfurt will actually send you a letter, say your statute is about to end or about to expire. If you're going to do anything with this case, you need to do it now. And that's for your protection, and that's good. That's a good thing, because it lets you know that, yep, if you're going to do something with your case, you better do it now. So I'm glad you brought up that point. Yes?
Is there a penalty against the employer if he does not file the first report of claim?
Absolutely. If they show intent to defraud or that it's clear and it was, they'll sanction them. And we've had a lot of that. And I always tell my people, I said, I don't care if you, they say, well, I don't believe old Joe got hurt. I'm not turning that in. It's going to cause my insurance to go. I don't care what you say. If somebody comes in and tells you you're hurt, write alleged. But you fill out something. Because if you don't, you're asking for problems. And Dwight Lovin, you all had Dwight up here. He's a commissioner. He was my former law partner. He got axed. He was actually, first he was a judge, and then he was a board member. And all of a sudden, I was on a cruise somewhere, and they called me. You know, a lot of this is political. I mean, this is a very political system and a very political issue, okay? And so they called me and said, Dwight just got fired. It's like 2 days after Christmas, and he was a judge. I said, he got fired, and that's when a new administration came in. You know, when the Republicans come in, they bring their people, and the Democrats come in, they bring their people. It's politics. That's the way it is. And they can fire them at will, okay? So my son called me and said, what do you think we ought to do? I said, let's hire him. Let's open up an office in Owensboro and get an office. So I called Dwight, and I said, Dwight, you want to go to Owensboro? That's where he's from, and have an office? He said, how long will it take you to get my office open? I said, how about tomorrow? So I called my secretary. I said, get him a fax machine, get him an office, get me a lease, and let's go. And we had him office open in about 2 days. And he stayed with us until he became commissioner. And this governor, Steve Beshear, appointed him. And he's done a very good job. He's a very sensible, calm gentleman. And he's good for the system. And that's what we need. Now, that doesn't mean when the next governor comes in that he won't be gone, but he'll have all his time in then so he can retire and get his money and all that kind of stuff, which is what you want to do anyway.